types of background it may come. So that's why patent might be relevant for all of you. What is covered in this class is first the basics of patent, then criteria of patentability in India, then non-patentable inventions in India, then types of patent application, and opposition and revocation also. So if I see that there's not time because we just have 1 hour of time, so in that case, we will stop after non-patentable inventions in India. Okay, so what is a patent? A patent is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something through that process, or offers a new technical solution to a problem through that product. To get a patent, technical information about the invention must be disclosed to the public in a patent application. So you get a patent granted when you have applied to that patent office and when you have disclosed all the information. If you hide everything, the patent office will not grant your patent. Okay, this is the definition that one of you guys just found it out. The patent is an exclusive right granted for an invention. This is the exact definition. It is available on WIPO. WIPO is World Intellectual Property Organizations. And this is the full form of WIPO, World Intellectual Property Organization. So you might want to remember these things, that patents are given for inventing new product or process that is useful in day-to-day life. So that thing needs to be useful. Whatever you are inventing, it needs to be useful. Give me a moment. Product, inventing new product or process that is useful in day-to-day life. And this process of getting a patent is also. Then why we need patent? The patent system. This might be important for your exam. Why we need the patent system? Because it fosters technological innovation by providing. Slide number 4. You can take a screenshot. How to get a patent, we will discuss in the next class on Monday. So this is about the outcome of your research. You guys are from postgraduate streams. However, if you are doing any research in any project or something, so there is a common route of the outcome of your research, that is the publication. Write a paper, and then on your research outcome, then you send it to a journal. Then the journal sends it to a few reviewers. Those reviewers will review your paper and they will decide whether it is acceptable or this is not. They can fully reject it also, they can accept it also as it is, or they can ask you to modify also. So in that case, you will modify your paper and send it to them again, and then they will publish it. That is called your journal publication. However, in this class, we are talking about patent. So here it is just written acceptable with a major or minor revision, or accepted or rejected. This kind of things may happen. Then what is the result of it? You publish a paper, right? And that paper you will add in your CV, and you add some fame and glory to your CV, as you can understand. There is an alternative route to that. That is, you have a patent. You can get a patent. So here in this case, you don't send the research outcome to any journal for publication. Did you get it? You don't send it. You file a patent application before sending it to a journal for publication. Please remember this. Please remember this. Before sending it to journal publication, you have to file your patent application. Otherwise, your novelty will be lost. So in this case, in this timeline, first you file the patent application, then patent office, you file it to the patent office, right? Last time somebody was asking if any country can apply for a patent or something like that. I don't know, you guys, I hope this is the batch. So countries do not apply for patent, individual people can do, or university or any legal entity can do like that. Okay, so the patent office will examine your application after you file the patent application. So the patent office will examine your application. If your application passes through the examination, that means it satisfies all the criteria and something I'll discuss about it later. So you can get the grant, you can get the patent. So you get a legal right. So this is completely different than what you get when you send the paper for journal publication. Okay, in that case, that will be published. You will get some fame and glory or whatever, you can add it in your CV, but you don't get a legal right. But when you get a patent is a legal right. So when you get the patent grant from the patent office, you have something legal right, and then you can commercialize the patent also, and you can generate money out of it. Now people will be interested. Okay, so you're out. Every other person who doesn't have his or her authorization, the patent owner has the exclusive right to stop or prevent every other person. How long somebody can enjoy the patent right? That is 20 years from filing. If you guys are not listening, please listen to this again, because I will have some exercise after this slide. How long one can enjoy the patent right? 20 years from date of filing. Where is your right available? A patent is a territorial right. A patent granted in India is valid only in India. Then people keep on asking me, how do I get a global patent for your invention? You don't get any such patent. You have to apply to that country and you will get the grant in that country only. And as I said, the patent owner has the exclusive right to prevent every third person. That's why it is called a negative right. Patent is a negative right. Okay, patent is a negative right because the guy doesn't get the automatic right of using his invention. He gets the right to stop every third person. That is why it's called a negative right. Okay, give me this answer. You have filed your patent application on 1st September 2020. Your application was published on 1st April 2022. On 29th September 2022. When will your patent term expire? These are the answers.
2040.
Say it again.
September.
29 September 2042.
ఏం చెప్తున్నారా?
Okay, so I heard somebody said 29 September 2042.
29 September, ma'am.
2042. 20 September.
29 September.
20.
29 September, ma'am.
Told you.
29 September
Okay, nobody is listening.
2042.
See here on this slide, you can see it. How long can I write? That is 20 years from date of filing, not from the date of grant. Now tell me here, from the date of filing, not from the date of grant. So it may so happen that you have filed your patent application today and you get your grant after 10 years. Still, your patent term will be calculated from today, not from 10 years when the patent is granted. Now tell me.
1st September 2040.
Right.
September 2040.
September 2040.
Okay. So you have to see my slide, and when I'm saying see it, the exercise is coming, you have to listen so that you can answer, right? So this is clear from the date of filing, not from the date of publication or not from the date of grant, date of filing, the tab. Okay. So what kind of right the patentee will get? Patentee means the patent owner who gets the grant, that guy will be called as patentee. So what kind of right the patentee gets? That is mentioned in section 48 of Indian Patents Act. So where the subject matter of the patent is a product, there can be two kinds of patent. As I told you, it can be a product or a process. So first of all, where the subject matter of the patent is a product, the exclusive right of the patentee is to prevent third parties who do not have his consent from the act of making, using, offering for sale, selling, or importing for those purposes that product in India. So basically the right is to stop every other party, right? So when it is a product, the right is to stop what? When it is a product, the right is to stop every other party from the act of making, using, offering for sale, selling, or importing that product in India. Look at point number B. When it is a process, the exclusive right is to stop every third party who do not have his or her consent from the act of using that process and from the act of using, offering for sale, selling, or importing for those purposes the product obtained directly by that process. So this is written in legal terminologies that it might look like, it's learning for 4 or 5 lines, but this is basically very simple. When you have a product, you don't have the right, if you are not the patentee, you don't have the right to sell it, use it, or offering for sale or import it. That is a product, right? If it is a process, you don't have the right to use that process or do the same kind of thing for a product which is directly obtained by that process. So these are the two simple patent owner will get. This is the first patent in India. This is just for GK. The first legislation, I think I have told you this in my last class also. The first legislation in India relating to patent was the Act 6 of 1856. The first patent was filed in India at Kolkata. You can see on your right, that is the patent for not the girl. You have to look over. That is the pankha. Pankha means fan. The hanging. Right. They have to pull it sitting outside of the room. You can see on top of that photo. So on 3rd March 1856, a civil engineer named George Alfred de Pinning from Calcutta filed a petition for grant of exclusive privileges under this act for his invention. The title was An Efficient Pankha Pulling Machine. In those days, you can see the string also coming out of that pankha. Some guy used to be sitting outside that room and he used to pull that. So George Alfred, he invented something that is like a machine that is pulling it. So no manual intervention is needed. The present Patent Act 1970 came into force in 1972. This I have already told last time. Okay, this is another important thing is that the patent is for invention, not for discovery. Please remember, in legal terminologies, these two are completely different. Invention and discovery, these two are completely different. Patent is given for invention, not for discovery. Patentee gets the legal right to stop everyone from using, making. Patentee gets the legal right to stop everyone from using, making, selling, offering for sale the patented invention without patentee's consent. I already told you this. What if the patents are given for discoveries like mathematical formula or equation like E is equal to mc square? What if you get a patent for that? Then basically you are stopping science on earth. You are stopping the progress of mankind. So for the discoveries, you don't get a patent. You get patent only for invention that is useful in day-to-day life. So patents are given for invented device, process, composition that is useful in society, making sure that no basic science discoveries are stopped by patenting process. Okay, that's why when if Einstein invents E is equal to mc square, string theory, those things are not patentable because you cannot stop mankind to use the advancement of science. You cannot do like that. But if I find something that may reduce the room temperature or something that is useful in day-to-day life, for those things you can get a patent, not for some groundbreaking discoveries. Discovery is different from invention. Hope that is clear. Okay, again, patent is for invention. Please remember, patents are for invention useful in day-to-day life, not for groundbreaking discoveries like Earth has gravity or relativity theory or string theory. For example, if I give you the patent because Newton discovered Earth has gravity, then everybody stops using it. That doesn't even make any sense. Earth has gravity and I'll be pulled down to Earth if I jump. Nobody can stop me from getting closer to Earth, right? So you cannot get a patent for that. So please remember, discovery is different. Under legal terminologies, invention is different. But you can see how you can get a patent also. On April 10, 1849, Hunt, some guy named Hunt, he was granted a US patent number this for his safety pin. Safety pin, you know, those thing that you put over here, some sari or Indian ethnic wear, then maybe you can use it. I don't have it. I could have shown it. I hope you guys know. For that, he got a patent, but not Einstein got a patent for E is equal to mc square, right? So you can understand whenever something is useful in day-to-day life, then you can get a patent, and patent is not for lifelong. You get 20 years. As I just said, it will be 20 years from date of filing. Patent applications are mostly filed from applied science departments. Now, don't blame me if you guys are not from applied sciences. I'm supposed to teach you this. What is an invention? Yeah, so this is not my writing. I'm not writing it. This is just according to the law, Section 21J of Indian Patents Act 1970. I hope you guys understand, right? This is a legal subject. So for legal subject, they will have sections. Since I am also coming from a science background, I understand you guys will face some difficulty. What is this section? Why do you need to remember this section? But this might be easy. Section 21J of Indian Patents Act 1970 gives this definition that invention means a new product or process involving an inventive step and capable of industrial application. So which one is it has inventive state. The third one is it must be capable of industrial application. The second one, inventive state, that terminology is used in India. In US, there is a synonymous terminology that is called non-obvious. Okay, that is in the US, but the funda is the same. In Europe, again, it is inventive state. And your invention must be novel, just means new. On your screen in the definition also you can see a new product or process. So the new thing is the first criteria, that is novel. Second is inventive.
No.
Okay, good. The third one is must be capable of industrial application. That just means the invention is useful. The term useful will be used in US. Sometime it's also called as utility. So it should be useful or has utility. So I can share the PPT also. Yes,
Thanks.
with you also. So this is important, guys. Please, this is slide number. This will come in your exam, okay? These are the 3 points. This will come in your exam. These are the definition of from the Indian Patents Act. For this terms novelty, first one is novelty. It means it has not. Don't talk, guys. You can mute yourself. First one is novelty. That means it has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of the patent application. That means it is novel or new. Second one is inventive step. It involves technical advances compared to the existing knowledge. So whatever is already there in the world, you have contributed something into that, and you have made some advancement in that knowledge. Or so there are two criteria. First of all, you can contribute to the technical advancement, or you can bring out some economic significance, or both. So either point number A, technical advancement, or point number B, economic significance, or both. That makes the invention not obvious to a person skilled in the art. If you guys are interested in pursuing your career in patent or in IP further on, this middle definition is very critical for you guys to remember, because there are so many terminologies that is used over and over again in the Patents Act. Technical advancement, economic significance, not obvious in the art. A person skilled in the art. This is very important. The third one is capable of industrial application. That means the invention is, that doesn't mean, it is the definition. The invention is capable of being made or used in any industry. That is section 2(1) AC. You don't have to remember the section. Now, how do you determine novelty and inventive step? This I am not, I didn't generate this chart. This I took from JPO, that is Japanese Patent Office. JPO, you can see on your right on the screen. First, you determine the claimed invention. How do you determine novelty? Okay. First, you determine what is the claimed invention in the patent application. Then you determine the closest prior art. Basically, you see what is your invention in that patent application. Then you find whatever is there in your search material. Prior art you can see in patent databases, non-patent databases, somewhere. You just see in Google also. So those things, everything will be prior art. Then you identify the difference. There is a difference between your claimed invention and the prior art. If you guys talk, I imagine you guys are asking something. R Mohana Manasa. Please don't talk. Okay, so if that invention and the prior art, they are identical, so it lacks novelty. So your invention is not novel, you are not going to get a patent. Satya, can you mute this guy? Okay, I have muted. Satya, please help. You don't have to come. Whenever these guys are talking, you can just mute themselves. I have just muted. Okay, so whenever there is a difference between the prior art and the claimed invention, so your invention is novel. Now they will check whether there is inventive step or not. That means whether this is obvious or not. If it is obvious, there is no inventive step. If it is not obvious, then only you have inventive step. So on your screen, you can see the claimed invention lacks an inventive step. That means it is obvious. When it is not obvious, it involves an inventive step. Now, this is also an important terminology in Patent Act, that is FOSITA. A person having ordinary skill in the art. The abbreviation is called FOSITA. That is a hypothetical person whom we will decide that FOSITA has got the knowledge on the date of filing of that patent application or not. If he has got the knowledge, then it is obvious. If he has not got the knowledge, it is not obvious. So this is a hypothetical person. So this is just the same thing, whether this thing is obvious or not, how it will be understood. The following points needs to be objectively judged. You can see from where I found it. No, maybe you cannot see. So the following points will be looked after. The first, you identify the person skilled in the art. So you have to identify somebody like that who is a competent craftsman or engineer as distinguished from a mere artisan. Then maybe I told you about prior date. If I didn't, I will say later. Then you identify the inventive concept of the claim in the question. That means in the patent application. If that cannot readily be done, then constitute it. Then identify what is that by chance, Mr. Sharath, that hand. If it is not, then I will answer your question after some time. Let me continue. Identify what, if any, differences exist between matters cited as forming part of the state of the art and the inventive concept of the claim or the claim as constitute. Viewed without any knowledge of the alleged invention as claimed, do those differences constitute states which would have been obvious to a person skilled in the art, or do they require any degree of inventive ingenuity? So these are the whole process of how do you understand whether this thing is obvious or not. You have understood that you need to see the novelty at first, then you need to see the inventive step. In this case, assume that your invention passed the 3 criteria of patentability. So it is novel, it is not obvious, it has got inventive step, and it is useful also. So now you are excited that you are about to get your patent soon, but still, in office rejected your patent application. So what went wrong? You have invented a device for theft and burglary. So Indian Patent Office rejected your application. So this will still happen. So if you think that you have only satisfied the 3 criteria of patentability and anyhow you will get your patent, that will not happen. You have to see whether it is falling under non-patentable subject matters or not. This is the you can mute some people. I have muted. Okay. Now, here, as I said, that there will be something more than just seeing whether we take later. First, novelty plus inventive step plus industrial applicability will constitute an invention according to the definition. However, in that Venn diagram, you can see that Okay, so I'm